In this video, we're going to talk about excessive force and the use of deadly force by police officers. It's a topic that is always in the news anytime there is a controversial police shooting. And we get a lot of questions about this, so we'll try to answer some of those questions here today. Let's start with the constitutional provision that applies in these cases. So all uses of force by police officers are governed by the Fourth Amendment, which prohibits unreasonable seizures. Anytime the police use intentional force against a person, that person is seized, and the Fourth Amendment applies. And that means that any use of force must be reasonable. And that's true of deadly force as well. So what does reasonable mean? To answer that, we have to start with the Supreme Court case called Graham versus Garner. This is a case that reached the Supreme Court from Charlotte, North Carolina. In November 1984, the plaintiff, DeThorne Graham, was a diabetic who had an insulin reaction, and he had a friend drive him to a convenience store, and he ran inside to go buy something from the store. But he saw that the line was too long, and he quickly sprinted back out and got back in the friend's car, and they drove away. So Garner was a police officer with the Charlotte Police Department, and he saw all of this and thought that it was suspicious. So he followed the car and pulled them over. Graham got out of the car, ran around it 2 times, and passed out. And by this time, there were more police officers on the scene, and they rolled Graham over on the sidewalk and handcuffed him. Then they propped him up on the hood of the car. Graham woke back up and tried to explain, he's a diabetic, but the officers didn't believe him, and they shoved his head into the car and yelled profanities at him. And then finally, the officers received a report from the convenience store that Graham had done nothing wrong, so they drove him home and let him go. Later, Graham filed a civil rights lawsuit, and the legal question in the case was, what is the standard for excessive force? Did Graham have to show actual malice? That is, did he have to show that the officers intended to harm him? Well, the Supreme Court said no. And they said that instead, courts should consider these factors. They are the severity of the crime at issue, whether the suspect poses an immediate threat to the safety of the officers or others, and whether he is actively resisting arrest or attempting to evade arrest by flight. So that is the Graham versus Garner test, or the Graham versus Garner factors. Now let's talk about what deadly force means. It's something that is easy to take for granted in a shooting case, but what about beanbag rounds or police squad cars or chokeholds? There are cases holding that these types of force could be deadly force in a given set of facts. Other uses of force, like tasers, for example, are usually viewed as something less than deadly force. So one suggested definition for deadly force from the Model Penal Code says deadly force means force that the actor uses with the purpose of causing, or that he knows to create, a substantial risk of causing death or serious bodily injury. Whether a use of force is deadly force matters because the ultimate question is whether the force was reasonable. So the question in a deadly force situation becomes whether officers are justified to cause death or a substantial risk of death. A very common question we get is, are there special rules for deadly force? And the answer is sort of. So every use of force, deadly or not, is analyzed under the Fourth Amendment, as we've said. But we need to talk about a case called Tennessee versus Garner to explain that the Supreme Court has addressed deadly force specifically. So Tennessee versus Garner was a case that reached the Supreme Court from Memphis, Tennessee. And in October 1974, Memphis police were called to the scene of a nighttime home burglary. And when they got there, they saw someone running in the backyard. An officer named Elton Hyman was able to shine a flashlight on the suspect and see that he was unarmed. So Hyman called for the suspect to stop, but the suspect started climbing the fence in the backyard. Hyman shot the suspect in the head, killing him. And it turned out that the suspect was a 15-year-old 8th grader named Edward Garner, who was 5'4" and weighed 100 pounds. Now, those facts are in the Supreme Court opinion, even though there's not really an explanation of why they're relevant. But I think that the morality of this case sort of leaned on that side. At the time, Tennessee state law authorized using any force, any necessary force, to detain a fleeing suspect. So the shooting was legal under state law. But the Supreme Court of the United States held that the use of the force violated the Fourth Amendment. And in a key passage, the court held, quote, "The use of deadly force to prevent the escape of all felony suspects, whatever the circumstances, is constitutionally unreasonable. It is not better that all felony suspects die than that they escape, where the suspect poses no immediate threat to the officer and no threat to others. The harm resulting from failing to apprehend him does not justify the use of deadly force." After Tennessee versus Garner, police can still use deadly force to prevent escape, but only if the fleeing suspect poses a threat to the officers or to other people. So this rule still allows the police to shoot at someone who is running away. Police officers can still fire shots at a car that is driving away, and even shoot someone in the back. So those types of shooting incidents could be reasonable. So there aren't any per se rules on this. It's always going to turn on the specific facts in question. And the most important factor is usually, but not always, but usually, whether the suspects involved were armed and whether they were threatening the officers or anyone else at the time of the shooting. Another question I hear a lot is about the number of bullets used. So it's natural to think that it could be excessive force to fire 20 rounds when 1 or 2 might be enough, but that isn't the law. So if it's reasonable for the police to fire the first shot, courts have held it's reasonable for officers to keep shooting until the threat is neutralized. Of course, everything depends on the specific facts. If the police keep shooting long after the suspect has been overpowered or subdued, that could be excessive force. Again, everything depends on the specific facts. The next important concept to understand is something called qualified immunity. Qualified immunity protects officers even when they violate the Constitution. Basically, the courts will say officers are immune from suit unless the plaintiff can prove that the law was clearly established so that it would be beyond debate that the actions the officers took were unreasonable. So this is where most excessive force cases fail, because courts will require that the plaintiff produce a case with the same or very similar facts, and that's really, really hard to do. Qualified immunity, to put it mildly, is a controversial topic. Lately, there have been efforts to abolish it by an act of Congress, but for now, it is the law, and it makes bringing excessive force cases to trial extremely difficult. It's really why you need to hire a really good lawyer if you have one of these cases. So I hope this video has been helpful in explaining some of the basics of excessive force and deadly force. You can check out our website for more information. Please like and subscribe for more videos like this. Thanks.